Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today we are going to talk about what estate planning documents remain good when you move from state to state. Before I get into that, I want to give you my contact information. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can follow me along on social media at Amanda Rocha Law. The reason I want to talk to you about this today is because I have had a few different clients recently who have moved to California from other states with existing estate plans contact me. They contacted me originally to just ensure that their estate was up to date with their new home, not realizing that many of the other documents that they had no longer are good in this state. So let's dive in. First, if you own a home outside of this state, and let's say you moved from Texas to California and you had a trust in Texas that owned your home there, and that was the only thing funding your trust, and you moved to California and you wanted to put your home in the Texas trust, well, you no longer live in Texas. So your trust there isn't going to follow California laws. And while you can own property outside of the state in your current state's trust, if you're moving there, you need to have a trust from that state to follow that state's laws. Not only are there laws on how to set them up and what to put in them, but how to execute them and all of that. Wills, again, your will is going to be executed in either the way that the state has told you to do it, or you could have a will that was set up in a way that was a uniform way that most states cover. Unfortunately, in California, we like to do everything different. So California has our own requirements on how to draft a valid will. I think it is important that you update your will when you move to California. Now, if you had a HIPAA release, that will remain fine. If you had a durable power of attorney that was not a state-specific document and didn't necessarily follow the rules and execution rules of another state, there are federal rules that you can follow that might be okay, but California has our own document as well. We also have our own advanced healthcare directive. Sometimes people have different documents for healthcare powers of attorney, and just depending on how it was filled out there, you're going to have a new attorney look at it and tell you if it matches the rules here. Sometimes we need to add in certain clauses for California's probate code sections that will allow your documents to be up to date, and sometimes they aren't even signed in the correct way. California requires notaries for certain documents, witnesses for different documents, and nothing for others, just your signature. It could be that another state has a conflicting rule on that, and maybe you had your will notarized somewhere else, but in California it has to be witnessed by two people. So always make sure that when you move into another state, that your estate plan is up to date there. Some documents remain the same, some of them don't. It's just going to depend on what you have and how it was executed. If you have a question like this, give me a call, schedule an appointment on my calendar. I will give you a call. You can find my calendar on my contact page on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me on social media at Amanda Rocha Law. Thank you.